I'm glad to introduce our next speaker. David Friedman is professor of law at Santa Clara University. He received his PhD in physics from the University of Chicago. He's been a John M. Olin Faculty Fellow at the University of Chicago Law School, a visiting professor at Cornell Law School, associate professor at the Friedman School of Business at Tulane. He's contributed to many scholars and volumes. He's the author of numerous books, including Future Imperfect, Law's Order, Hidden Order, Price Theory, and probably his most famous book for many of us is The Machinery of Freedom. He's also a distinguished novelist, have novels of Harold and Salamander, and I understand a new one that might be called Eric. David?
I figure that Ed went about 2 minutes over his time, and I think tort damages of $1,000 a minute to be divided between the two victims of this tort would be reasonable. And conveniently enough, we have a judge available to settle any disputes about the case. All right, so I get 60%, you get 20%, right? It's a deal. All right. The standard economic approach to the law consists of assuming that the individuals involved with the legal system act out of their own rational self-interest. And we apply that approach to criminals. We apply it to their victims. We apply it to tortfeasors. We apply it to their victims. We apply it to people who sign contracts. We apply it to producers and consumers. But we almost never apply it to the other side of the legal system, the people who make and enforce the law, to the judges, the police, the prosecutors, and the legislators. And that's a serious gap in the theory as it now exists. And I think this book takes at least a useful first step in the direction of filling that gap. It doesn't really work out a full-blown theoretical scheme that incorporates all of those, but what it shows is that indeed the empirical evidence strongly suggests that judges, prosecutors, legislators, the people involved in making and enforcing the law, are also rational, self-interested actors and should be understood in that way. That said, what I would like to do is to discuss the question of how you might improve things, how you might change the system such that prosecution of crimes and torts produced more good results and fewer bad results. And then the more ambitious project, how you might rearrange the way the world runs in order that we would get good laws instead of bad laws. And in each case, what I'm talking about is not what laws should we have, but what institutions would make it in the rational self-interest of people to create good laws or good prosecution. And I'm going to start with the prosecution side of it, which is in a sense a smaller but more immediate issue. One of my interests is other legal systems. I teach a seminar at Santa Clara University, which goes through a range of historical legal systems, trying to take each of them seriously and understand it as a way in which some set of human beings solved the same problems we solve. And it's sometimes useful. One of the threads that runs through all of those systems is the incentive to enforce the law. If there's no incentive to enforce the law doesn't get enforced. But if there's too much incentive to enforce the law, people get convicted of things they haven't done because it's profitable for someone to do it. And that's basically the class action problem that was being discussed here. And I have a number of particular solutions, but I would like to point out that the ancient Athenians, who were a little bit crazy but very smart, recognized this problem and they had a solution to it. In the Athenian legal system, what we would think of as crimes were privately prosecuted. And the incentive to prosecute them was the prosecutor got a large cut of the fine that the defendant paid if he was convicted. And that raises the obvious threat of look for deep pockets, think up some excuse to claim he did something, and then ask to be paid off not to prosecute him. This is in front of a jury of several hundred people in a system where all sorts of rhetorical devices were legitimate in pleading. Under Athenian law, however, if the prosecutor failed to get 20% of that large jury to vote for conviction, the prosecutor was fined. So it's interesting to think about whether some variant of that might be used in our legal system to reduce the incentive to engage in lawsuits where the odds are you're going to lose, but the threat that you might win is enough to get you paid off, because there's now a threat in the other direction. Let me look at a related problem mainly in the criminal context. We would like a legal system where the people who are doing the convicting have a reason to try to convict guilty people rather than innocent people. And in theory, our rules for how we do trials are an attempt to do that, to attempt to make it harder to convict the innocent than the guilty, although an attempt which is far from completely successful, as we all know. I would prefer to find ways which improve on that. And the obvious solution to an economist is that when an innocent person, when somebody who is convicted is shown to be innocent, make the people responsible for convicting him liable, make them owe very large damages. That is a very dangerous solution, because while it is true that is a punishment, it's not exactly a punishment for convicting someone who's innocent. It's a punishment for convicting someone who is discovered to be innocent. And thus, while it's an incentive not to convict innocent people, it's also an incentive, if you do convict innocent people, to make sure nobody ever finds out. So that's a rather double-edged sword. I have a better solution, and discussing it in detail would require a long digression into the legal institutions of 18th century England. People who are curious can find the article on my webpage. But find a way in which the people who are hiring the prosecutors want crimes prosecuted in order to get private deterrence, in order that it will not be in the interest of criminals to commit crimes against me. Because if the reward for convicting somebody is a bounty, then when my property is stolen, it makes perfectly good sense to grab the first homeless man who wanders by the door, frame him, and get him convicted. But that does no good at all if what I want to do is to make sure that criminals know that I'm a dangerous guy to rob. So if you have a system where private deterrence is what's driving the incentive for enforcing criminal law, you then have a system where the people who are doing it actually have a reason to care whether you get the right person or not. Let me mention one other small solution to or improvement in our system, which I and Steve Schulhofer wrote about a good many years ago, and Cato has now gotten us to rewrite in a more popular way our article. And that's the choice of lawyers to defend indigent felony defendants. As you may know, a sizable majority of all felony defendants are indigent and have their lawyer provided by the state. As you may also know, the choice of the lawyer is made by the state, not by the defendant. So that means that in a majority of all felony cases, the defendant's lawyer is working for the prosecution, in the literal sense that in a criminal case, the case is the state of California versus. May not be working for the prosecutor directly. He's a different employee of the state, but he's working for the state. And Steve's idea, which I signed on to and we wrote an article on, was that instead you should have a voucher system. You should say whatever amount of money the government is willing to pay for the defense of indigent felony defendants, let that money be paid to the lawyer chosen by the defendant, not chosen by the state. There's a story that goes with this. Steve was thought of as on the left of the faculty in question. I was thought of as on the right, or at least libertarian side, and there was some discussion as to which of us had subverted which. And I thought the answer to that was perfectly clear when we gave a law and econ workshop on the paper, and I had the pleasure of hearing Steve Schulhofer preaching to Judge Posner on the virtues of the free market. All right, let me go on now to the question of how to get good laws. And the basic answer is to get some mechanism where the people who are going to be under laws choose whose laws they'll be under. And there are a number of real-world examples. One of them is private arbitration. Two firms sign a contract. They agree that it will be arbitrated by the American Arbitration Association or some other organization. And the American Arbitration Association then has a straightforward, self-interested desire to write that set of legal rules that people want their cases decided under. All right, so that's a good example. A more imperfect example, but along the same lines, is choice of law of various sorts, so that most corporations are under the laws of the state of Delaware. And presumably that's because the state of Delaware succeeded in writing laws corporations wanted to be incorporated under. And there are difficulties which I won't go into, but at least suggests it. Finally, freedom of contract, saying we can write the rules that apply between us, is another approach to doing the same thing, because it's in our interest in drawing up a contract to try to draw the contract that maximizes the size of the pie that we're going to be dividing between us. But as it happens, I don't really have any good general solution to the prosecuting problem. I do have a good general solution to the legislation problem. I published it now about 40 years ago. In my book, The Machinery of Freedom, I sketched out what a society would look like in which there was no government and in which all law enforcement was done by private firms, in which the basic mechanism was that a firm sold me the service of protecting my rights, that each pair of such firms contracted with a private court to settle disputes between their clients, because fighting is really expensive. It's even more expensive than litigating, and therefore it's the interest of the firms to have some peaceful way of resolving the disputes. And in that context, the private judges of that system have a clear incentive to try to draw up the legal codes that the customers of the rights enforcement agencies want to be under, in order that rights enforcement agencies will choose those courts. For those who are curious, I won't say I have a book to sell, because at the moment the book is effectively out of print, but that's all right. You can get it, download it for free from my webpage. It's called The Machinery of Freedom. Someday there will be a third edition, but not yet. I suppose my final comment to make with regard to the next speaker, who seemed reluctant to accept my division of our loot, is that I can claim only one basis for superiority to Judge Kozinski, and that is that I was accepted by the University of Chicago, and he was not. And I know this because the first time I met Judge Kozinski was when he gave a talk at the University of Chicago Law School, where I was then a faculty fellow, and he began the talk by reading to the students his rejection letter from that august institution.